2021 between J2 Global Gas and Oil and Erasmus Onoha. But 3 months after independence,
Yes, appearance.
For and then if you pay more, I completely appear for woman with me, my blended friend, be and was with
Yes.
Very good. I'm Dr. James E. Paul. Humble appearance of the defendant who's present. Action. I'm going to apologize to my Lord for the systematic today that we are today. It's our country, we are still doing it. The good today, but our affected my thoughts.
Yes. 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 Yes.
We applied the same application. Yeah, emotion. I believe is a hamlet. They have this. Because it's money and
Yes, Councillor. I'll be set for the motion. Please take your motion.
On the motion, the 13th March. Yes. But in view of the fact that the implement is not and
yes.
Those of that.
motion dated the 13th day of March 2026 is granted as read. Yes.
Yes, witness. Remember the last time we were here, I referred you to paragraph 44. Witness with mention your spreadsheet. Do you remember? The witness I'm asking you. Erasmus, are you hearing us?
Okay, I can hear you now. Go ahead.
Yes, my question is directed to you. Last time you were there, we referred you to paragraph 44 of your witness position, where you talked about the spreadsheet of the jobs you did while at is that correct? Hello, witness, are you with us?
Yes, I remember the turn from what he has, something like that.
Okay. Hello, witness, are you with us? Look at the document that I'm showing you now. That's the spreadsheet of
Yes, if I see it, I'll recognize it.
I'm showing it to you now. Is that the document?
Exactly, that's it.
Thank you very much.
I will object to the accessibility of the document. On the ground that not signed.
Yes.
On the ground. Not dated. It's not authenticated. Not dated as a document that emanates from any person or a body. On that ground, we object to that. So,
Yes, no problem. That's what I'm. So the
From
small people doesn't apply. By the person who's the guy. The document relevant to the proceedings. Pleaded. And it's admissible in session. Still. That's what all the evidence act announced to make out. Having identified the document, no other authenticity is more than that. And also, an argument that left from that. But I've already argued that argument is misplaced. This argument is that question. split it is relevant. It's being tendered by the maker who has identified it as his compilation of the work he did. No more authentication is more than the man who says this is a document.
Sign, was also not closely origin or disputed. And finally, was not be authenticated by what the court rejects sent. This response, the land has also noted that the state document such a standard 2 was made by Assembly 1. Similarly, it has been authenticated in accordance with Section 83 of the Guidance Act. And it's also relevant to this proceeding. I will go through the documents such written as well as the arguments of both parties. So I say that that relevance is the this that's what been also shown by the objective that the said document is not relevant to this proceeding. That is settled, then by the combined effect of the issue of not cited above and section 80 of the Guidance Act, document is admissible and the access with D2. What you are saying is in accordance with Evidence Act.
Another case, all of this one. Parents wants to that person.
There's any examinations.
Yes, why not we start with some. Define the public call for the government. And witness, can you hear me?
Yeah, I can hear you now.
All right, good afternoon.
Good afternoon, sir.
Yes, your claim against the claimant is for the profit that you said was agreed to be shared from the contract you entered into, which is Exhibit D1. It is correct to say that the profit sharing agreement impose on you the obligation to seek arbitration to resolve any issue that has to do with profit sharing agreement. That's correct.
It's correct, but I'm not the one that sued the company. I was sued by the company. I hope you had my answer, sir.
Yes, right. the claim of the claimant against you is not based on the profit sharing agreement. That is correct.
They didn't mention the profit sharing agreement. So whatever they have against me is probably to dodge the profit sharing agreement.
The claim, can you hear me?
I'm hearing you.
The claim of the claimant against you before this court is not based on the profit sharing agreement. That is correct.
I answered that yes, they did not mention, they deliberately avoided the profit sharing agreement and started making other frivolous claims against me.
In the search document, that's profit sharing agreement, it is also stated that there will be certain deductions made cost of execution of before the profits will be shared. That is correct.
Operational cost, yes, it was mentioned, but it does not affect by 10%.
Now take a look at paragraph 1, paragraph 4.0, subparagraph 1 of the agreement. Do you have a copy there?
Please read it for me. I don't have a copy here.
All right. It says the employer shall compensate the employee with 10% of the profit realized from every contract transaction sourced, secured, and fully completed. This compensation is subject to the following. This compensation is subject to the following. The cost of equipment for execution of a project shall be set aside and paid to the company owners. 2, the operational cost for execution of project. 3, for every project, a certain sum agreed by the parties shall be set aside for recurrent expenditures, including staff salary. Plus 4.3. Yes, stop 1. Now my question is, did you, in your calculation of your claim before the court, were all these deductions made before this claim?
Yes, my Lord. In each contract we had, we factored in all those operational costs, including salary. And all the contracts were executed, our equipment returned to site, and the payment were made. We were not owing salary of my staff. We paid everything, and the contractors paid us, and we had our profit.
Yes, we'll be slowing down so that we can record you. We are recording by not high.
Yes.
Yes. Paragraph 2, paragraph 4.6, the 46, subparagraph 2 of your statement of defense and counterclaim is a claim for 103,312,000. That's correct. The law is already before the court. Now, in Exhibit D, the 10% of all the contracts listed here, which amounted to 1,033,120,000 naira. You made 10% of that sum to be your claim. That is correct. In Exhibit D2, that you just said that.
My lord, the 10% in my claim is cumulative of all contracts we executed during my tenure, according to my agreement I have with the company.
You will agree with me that there were no deductions from your claim. The money you are claiming, there were no deductions before you made this claim, as stipulated by the contract.
Is it me that will do the deductions? I've told you how we run the company. We run company with budget.
Lord, that's not the question.
Please, just answer the question directly.
It's a yes or no question.
Yes.
I don't think it can be yes or no, my lord, because there are so many other things involved in running a company. We run annual budget. I cannot be deducting budget from every this. I don't know if you understand what I'm saying.
Sorry, let me guide you. When we answer this kind of question, you answer yes or no, and then put the explanation that qualifies what you want to say. You answer yes or no, then explain it where you want to qualify it, but you must answer it. Then you can explain.
Okay,
my lord. Sorry about that, my lord.
Yes.
Yes, there was no deduction.
As a law basis. That's okay.
But there were reasons where it appeared like that. I don't know if I can explain.
Okay, it's okay. You answer the question.
Yes. Let me explain the matter.
Like I was trying to explain, we run the company by annual budget. Management gives us money to run all our current expenditures, capex and opex. And now we award contracts, and our business is leasing of equipment. We lease equipment, that is our major source of income. Our equipment have been bought long ago as assets of the company. Now, if you check what we are talking about deductions, one of them mentioned the cost of the equipment. How are you going to deduct cost of equipment from just one single contract? That was why I said our equipment has been bought as assets long ago. So when we now lease, yes, from the profit we are making, the owner of the company recovers the money he has already spent on purchasing the equipment. And now from there is where we run our OPEX and pay our salaries. But what I was told before I came, equipment had been purchased already before I came. So my percentage is on whatever contract I was able to get for the company. I don't know if that clarifies my position. Thank you.
Now, the document exhibit D2. You prepared exhibit D2 for you to be able to prove your claim before this court.
Sorry, come again, my lord.
You prepared exhibit D2 to enable you prove your case before this honorable court. That's correct.
If it's a spreadsheet you're talking about, yes, it was prepared by my accountant. I didn't personally prepare it. We have someone that updates and populates all our contracts and feeds me because I am the managing director of the company. I was the managing director of the company. So every week, my accountants and the people in that department updates our assets that are leased out. They populate that spreadsheet you saw. Because managing director, I cannot be doing everything now. I'm managing a lot of things.
Is there anything on the face of this document to show that the accountant of the company prepared this document? Because your counsel said that you that identified the document prepared it. Is there anything to show?
The company is a continuum. The company is still there. As a counsel of the company, I believe you should, if you go to the company, they will still show you this same record. My record, unless they have deleted my record in the company.
Is there anything on the face of exhibit D2, that's the spreadsheet, to show that the accountant of the claimant prepared the document and issued it? Now he said, can you hear me? The Rasmus, can you hear me?
Witness, can you hear us now? Please, can you hear us from here? I see the check. Okay,
Please check.
If you're okay, then you're okay.
Can you hear us now?
Mr. Laura, can you hear us?
Please, can you hear us now?
Please unmute your mic so that you can talk.
I see the boy, you can move from there.
Places.
Please, can you hear us? The court is waiting now. Can't hear you from this time. They say you should unmute yourself. You can't wait here. See that. The only thing is for you to unmute your mic. We can't hear you from the system. I'm only talking to you. So check your system and let us hear you. Otherwise, the court out.
Yes, witness, are you to us?
He's talking, but we can't hear.
It's just for him to.
If you can hear us, can you unmute your mic? So he's not hearing. God, they cannot hear us.
But he said he cannot hear us. So, you know,
Yes, his network is being off and on. I just
But I would suggest that if he can come, we can just use one day and examine him physically.
Yes, Dr. Muhammed.
the Reverend Council is getting late. But one day that I'm running don't get it. Our plan is that this thing will work down. Any other arrangement like this. I don't know why the system will now collapse on our face. But it's not that. The issue is not whether it comes on. The issue is what someone is waiting. If it is from the goodness, we expect that.
Can I ask him?
Hello, can you hear us now?
Yes, go ahead. Go ahead.
Right. Exhibit D2. There's nothing on the face of Exhibit D2 to show. That's the spreadsheet to show that it was an accountant in the claimant's company that prepared and issued it. That's correct.
As it appeared there, that is correct. What is in my record as email sent to me by accountant.
Correct that there's nothing to show that the accountant was. Mr. Erasmus, you have a basic knowledge of accounting that before profit is arrived at, that expenditure has to be subtracted from income. That's correct.
I agree with you, my lord. But can I say something?
You have answered the question. Mr. Erasmus, can you hear me?
I can hear you.
Yes. In paragraph 6 of your witness statement on oath, you said that you negotiated your employment with the founder and the director of the claimant who interviewed you. It is correct to say that you were not employed by the claimant until you received your employment letter, which you signed after reading it. Should I repeat the question?
I understand their question clearly. The person that engaged me, the person that invited me was the founder. The founder.
Let me repeat the question.
I repeat.
in your paragraph 6 of your statement on written statement on loan, you said that you were interviewed by the founder. That's correct.
Correct.
But you were not employed by the claimant until you received your employment letter, which you signed after reading it.
The claimant here is J plus G, and founder is J plus G. They are inseparable. They are the same people.
Different answer you are giving. That's not the answer to the question. You were not employed. Your status was not as an employee of the company until you received your employment letter and signed, which you read before you signed. That is correct.
I had already started work before I was issued employment letter.
That's not the question. You were not employed until you received your employment letter, which you signed after reading it. That is the question.
I signed the employment letter after reading it. I signed it after reading it.
Okay. It's okay. That was the point you were employed.
Yes.
In that employment letter, it was one Collins Amadi, the then chairman of the advisory board, that signed it on behalf of the company.
Correct.
Now, it is your claim that you don't know the advisory board, that they did not exist. Do you still maintain that your position?
I maintain the position because the advisory board, instead of becoming an advisory, became something else, contrary to the agreement I had with the founder. They were purely advisory, but they were no longer advisory. They wanted to even take over the company.
Mr. Rasmus, can you hear me?
I can hear you. Yes, I'm hearing you clearly.
The employment letter you received make reference to the advisory board as the body that you are going to be reporting to. That is correct.
That was inserted by them. It wasn't my agreement with the founder.
So it is not correct when you said that you were never aware of the existence of the so-called advisory board.
I didn't say I was never aware. Please read my statement very well. They were there. But when I was interviewed, I never knew they were there. Nobody mentioned them during the course of my interview. They played no role in interviewing me.
You also said in your paragraph 6 of your written statement on hold that you were directed and compelled to be reporting to the advisory board. The question is, who compelled you?
When I started having my management, I started having problem with the advisory board. Some people who were not even staff of the company.
Just save time, please. Just save time. Because of network issue, we've spent a lot of time. Let's just save time. Who compelled you? According to your written statement, you said that you were directed and compelled to report to the advisory board. Who compelled you?
Apart from the founder, there's another man called Fonseca. Fonseca, second in command. There's another man called Fonseca, second in command to founder. He was the one that said I should be reporting to the advisory board, not founder self.
You just said that you read. You just told this court that you read your employment letter. Now, I don't know if you can take a look at it or you have a copy there. Or can you still remember the content? Because it is one of the conditions that you'll be reporting to the advisory board. That's correct. It is contained in your employment letter, which you signed after reading, according to what you said, that you should be reporting to the advisory board.
My Lord, I've told you that yes, I signed the employment letter. But I tried to explain to you the circumstances. You say I'm wasting the time of the court. Founder delegates to the advisory board, but the advisory board goes ahead to insert certain clauses that is beyond them. My employment advisory board played no role on how I came into the company. Some of them are not even staff of the company. Some of the advisory board, they are not even staff. Some are contractors. So you won't understand the structure of the company is somehow.
It's okay, we've gotten the answer. It is correct to state that your employment letter, which you signed voluntarily, embodies the terms and conditions of your employment. That's correct. It is correct to say that your employment letter embodies the terms and conditions of your employment with the claimant.
That is the role of employment letter. That's the role what the employment letter does.
As a court basis. Apart from oil prospecting, exploration, and refining, the claimant company has been in the business of equipment leasing before you got employment.
J+G Global Gas is a service provider in the oil and gas industry before acquiring equipment for leasing. I came into J+G when they started leasing. When they were into providing services, they were my own contractor while I was in Shell. That was how I came to know founder. He was my contractor in Shell. I was in Shell. He brought me to come and manage his company when he started leasing.
That's all right. Because you were in Shell, working for Shell, you wouldn't know the activity, the businesses that the claimant was carrying on. prior
I
to
just
your
told you
employment.
that they were my contractor. They repair pipelines for me. I was pipeline engineer in Shell. J+G was my contractor. They repair emergency pipeline repairs for me. I know them from that level before they grew to acquire leasing equipment.
That is just one of the services they render which you benefited. I'm asking you, because you were working in Shell, you wouldn't know other businesses that they were doing before you became employed by the claimant.
But when I joined the company, I saw the history of the company. And what I've told you was exactly what they were doing. I don't know of any other one. Because I know the history of the company, I became the managing director.
Yes. Now, you have stated in your written statement on oath, my lord, I can't see the particular paragraph. You stated that you prepared the lease agreement based on the templates of similar transactions in the company. That's correct. Please.
The template I prepared and presented were the jobs, contracts I awarded when I was managing director of the company. And it is on the basis of those contracts that my 10% profit agreement is what I'm claiming.
Now, the templates you were talking about, they are based on the existing or previous leasing agreement that was prepared by the legal department of the company.
I started leasing business for J+G. I'm the first managing director that started leasing equipment in J+G. There was no previous one, please.
Now, in paragraph 9 of your written statement on oath, along with your permission, I will read it to him. You said, I know that there is no standard procedure for leasing company equipment in the company. There is no document to that effect. Every lease conducted by me was carried out with the knowledge, without the knowledge of the then advisory board, Mr. Collins Amadi. The lease agreement were drawn up from lease templates created by the legal advisor, Ms. Phil Destiny. That is correct. That is your statement. Now, the question is, the templates that you relied on,
yes,
the documents that the company used in previous lease transactions.
Sorry, but the has already said I will not use I started it. How did you try that? He has already said I started equipment leasing in this company. It wasn't there before. So this question is leading to nowhere. Yes.
As the court is. Now, you were not the one that bought the equipment that you leased to other vendors. We're not the one that bought when you arrived at the company. That's correct.
I was in Belema Oil when the equipments were bought. And I was asked to move over to J+G and become the managing director. I knew when the equipments were bought. I knew when they were cleared from the wharfs. I was actually the one that played the role in clearing them and brought them to our jetty and started leasing. The first contractor that leased the equipment from us came from me. And I tell the legal department, after negotiating how much we are leasing, the legal department find that that lady mentioned that we now develop the contract agreement for us. That is how it works.
Yes. Now, all the lease agreements you entered into, according to paragraph 9 of your recent statement of goods, they were without the knowledge of the advisory board. That is correct.
Without you said they are without their knowledge. Let me understand you, please.
You said, let me read. Every lease conducted by me was carried out with the knowledge, yes, with the knowledge of the advisory board chairman. Now the question is, in all the lease agreements, is there any point that the approval or signature of the advisory board is affixed to show that they have the knowledge of it?
Yes, they have knowledge of all, because the lady who is the legal head that prepares the contract is also a member of the advisory board. She is the secretary of the advisory board.
Slow down, take it easy, so we can record you down. Yes, please. Slow down and stop. Go ahead.
I should come again.
Continue now. At the base, you can record.
Yes, I said yes to the question the council asked me. All the lease agreements are with the knowledge of the advisory board, especially Collins Amade and that lady, fine, I can't remember her full name again, because the lady that prepares all the contractual documents before equipment leaves jetty is that lady, and that lady is a member of the advisory board. In fact, she is the secretary of the advisory board.
Yes, Exhibit D2. Exhibit D2, the spreadsheet was not audited. There was no audit of all the transactions before you brought this out. That's correct. All the transactions, all the lease agreements that you claimed you executed, the money you said were paid for them, they were not audited by the account department before you brought these documents. That's correct.
Payments go directly to company account. I am not an auditor. It was not audited. But all the bank statements of company accounts, everything was reflected in our bank statement.
all the monies that you claimed you made as a result of the agreement, do you have any receipt or teller to show that you actually generated that money for the claimant? Do you have it before the court?
I can't have it because I have left I've left the company. We are banking with Access Bank. If you go to Access Bank today and ask for J plus J account, during my period as MD, it will be printed out for you. Nothing is missing in Access Bank because all payments go direct to company account.
Did you apply for discoveries of those documents that you claimed? Did you apply to the court to order the discovery of the document that you claimed exist in the claimant company?
Whether I applied to go to Access Bank, I did not. They will not even grant me if I apply to
Yes or no?
Access
Did
Bank.
you apply for
The
discoveries
company.
of those documents? It's a yes or no answer. Did you apply? Is it at this point of the case that you talk about the application to the bank? Did you apply?
Sorry, let me understand their question. Apply to who?
Did you apply for the company, the claimant, to release those documents? It's a yes or no question. Did you apply?
He's asking you a question. Please answer yes or no. Did you apply for the records from the company? As we are called, did you apply? Say yes or no.
I said I did not apply.
But I want to prevent a more appeal because I've been shouting and my head is aching. I want to apply just a very short date. Let me conclude with him. I'm having serious headache. Shout. Very not already feeling fine. Anyway, to lead to me shouting like this. I'll run off of it.
Yes. Another objective. I'm objective very good. All right. The person that has performed the presentation is not just how I used to do that. I've given the experience, yes, what to check. Well, he has been doing very well. I've done sufficient here. I don't think that is still anything I'm standing.
I know.
I understand.
Just like the level will not want me to stop before he agrees with me.
No, the point I'm making.
He's not a doctor.
The point I'm making.
He cannot assess me.
Point I'm making like that.
I know I want to appeal to the court.
I'm not finished my response. Yes. Well, the point I'm making is that we are expending money every day to come here. As much as I say it is important, if they will subsidize setting up of this in next time, they are the company. This is the one they sacked. And each step, they will swing them on. That has been our headache from day one. As a lawyer, I can come here, or he cannot be able to afford it. That's why I'm decided doing this one. A lot knows. I mean, he has asked for 20 questions, but I can't stop him. Yeah, he has said head guard because that's his easiest way. Let them subsidize this setting up of this another issues.
Yes.
But in our own place, they for examine him more than once. And secondly, like I said, I'm not really too strong. But I didn't have to tell the court when the court came in. But I needed to show good faith. I really need to proceed in this case. But if we come back in the same line, I'll be able to go. Lord, we have agreed to come back on the 18th of May, subject to the convenience of the court.
Dr. John.